and I know you're all just waiting for administrative rulemaking. So congratulations, you made it there. One more presentation, and then you can all go home. So that's me, my contact information, and we're going to spend the next hour talking about administrative rulemaking. Before we start, most important thing, arguably, is the resources. So take a look at this, and I know these will be available after the fact. I'd like to highlight the top two. Chapter 233B of the Nevada Revised Statutes is where all the administrative rulemaking laws live. Virtually every time I get a question about administrative rulemaking, I end up back there just making sure that the language is what I thought it was. Our administrative rulemaking manual is the one below it. It's only about 25 to 30 pages, so it's not too bad. Not that I'm recommending you all read it in lieu of this presentation, but it's a good resource in addition to everything we're going to talk about today. Also, the links to the administrative regulations, the preface to the NRS, and Killebrew versus State of Nevada, which is a decision we will be talking about in a little bit of detail. There's the link to that as well. Roadmap, this is what we're going to be talking about. First, what is a regulation? What isn't a regulation? There's laws, there's regulations, there's other things, so we'll go over that. Then we'll go through the process of creating them, how that works for all the different types, permanent, temporary, emergency. Then we'll spend, if we have time, we'll spend a little time talking about Killebrew because it was a good example of everything from the legislative direction to create a regulation, to the process to create a regulation, to the administrative review of that regulation, to the Supreme Court decision about what went right in that case. And then we got some final thoughts at the end. What is a regulation and what isn't? Part one. So we'll start off with laws. Obviously, laws are enacted by the legislature. Some of you are familiar with Schoolhouse Rock. Some of you are probably too young to understand that. But you know how a bill becomes a law, right? There's passage, there's signatures, and then that becomes a rule that governs the entirety of the state. Great. We have a biannual legislature, so they meet every 2 years. There's roughly 1,000 BDRs that come through. Not all of those become laws. There's only 63 legislators in the state between the Senate and the Assembly. So with that limited output of law-making ability, they can't get into the level of detail that they need to on all the different topics. So that is why they, in their wisdom, have decided to delegate some of their rulemaking authority to experts, agencies, boards, commissions, individuals who can put some of the detail work that they don't have the capacity to do into law. So the second part of this is probably the important one, which is agencies must have delegated authority from the legislature to create a regulation. So there is no implied, well, I'm the Department of Agriculture, so I can probably put a regulation in about onions, right? No, not unless the legislature says you have the general authority to adopt regulations regarding anything in your statute, which a lot of boards, agencies, and commissions do. But just know that whenever you're thinking about adopting a regulation, you have to have the authority from the legislature. And you have to be able to go back and point to a statute and say, this is the authority that was granted to me by the legislature to let me make this rule. And there's two types of authority. There's the general authority that I just mentioned, right? A good example here is 385-080, as necessary for the execution and the powers and duties conferred upon it by law. So that's pretty broad, right? You can sort of adopt rulemaking within anything that is under your purview. And an example of a specific is adopt regulations governing the control of rabies. Very small sandbox as opposed to the other one. So whenever you're thinking about making a regulation, just understand where your legislative authority comes from. Moving on to regulations. Regulation is defined by 233B-038. I won't read the whole description there, but it's included. And I frequently go back to it and read it whenever somebody asks about it. Important thing to remember is the general applicability of it. Whenever you're trying to put a rule in place that is going to apply to the general, the public, or some subsection of it, there's a good chance that that's going to be considered a regulation that should go through the administrative rulemaking process, meaning that you get the workshops, you get the public comment, the opportunity to come in and say, this is a good idea, this is a bad idea. These are not the sort of things that the agency can do by itself without going through the official process. And just like there is no implied ability to create a regulation, the process for the creation of the regulation is statutory. The legislature says these are the things you must do to create a regulation, and it's set forth in the other half of 233B. You just heard Todd. Well, if you're live, you heard Todd. If you're on a video, you may not know who Todd is. But the last presentation was about administrative actions, agency actions, disciplinary actions, which is half of 233B. The other half is the administrative rulemaking part. So it's a great chapter because it handles two of the presentations that we're going to deal with today. But 233 sets out the full procedures that you're going to need to follow for any of these regulations. And other, I mentioned that there are some things that go into regulation. There are also some things that don't go into regulation. There is a specific list of exemptions in 238B 038 sub 2. This is a list of some of the highlights. We just heard about decisions in contested cases, right? Those don't need to go through the regulatory process. Contractor agreement we heard about earlier with Mr. Doty's presentation. That doesn't need to go through the administrative rulemaking process. Advisory opinion that is not of general applicability. If somebody were to come to your agency and say, hey, I'm trying to do this one specific action. Do you think this is going to be consistent with the law? And you're issuing something that's agencies or that's specific to that individual. It's not a rule of general applicability. It would just be specific to that individual. Manuals of internal policies and procedures, also specifically exempted by 233B 038 sub 2. And this is only a partial list, but the bottom bullet point is probably what you should be paying attention to on this slide. The common theme of what makes a regulation is going to be general applicability. So whenever you're making this wide-ranging rule that's going to apply to the public or certain subsections like all licensees or all vendors or all participants, that's when you start thinking about this is probably a regulation. Further exemptions. 233B 039 exempts a number of entities. This is not all of them, but these are kind of the highlights. The governor, Kevin mentioned COVID earlier. Governor was issuing all sorts of orders and directives and policies trying to keep the state functioning. Any argument that those should have been regulations is undercut by the fact that the governor is specifically exempted from regulation making authority by 233B. Also, INSHE. Anybody here from INSHE? Feel free to turn your brain off now. You are exempt from rulemaking, so congratulations. Office of the Military, Gaming Control Board in some cases. So one of the things to also look at if you're thinking about making regulations, see if your entity is exempt. Maybe you don't have to do 233B. Maybe you have a different process, as some entities do. Department of Corrections has their own process. I believe Wildlife has their own process as well. So just be aware because there may be other processes that apply in specific instances. General applicability, we talked about it a little bit. This is a little bit more detail there. Again, rule applied to the general public that effectuates or interprets law or policy, often contains a mandatory requirement, affects the private rights or procedures of the public, and applies to the general public or some subset thereof. One of the things that is an easy way for me to think about this is if I'm going to put a rule in place, or one of my clients is going to put a rule in place, and they are going to want to use that rule to tell someone else what to do and say, no, we have a rule about this. It's right here, and this is what you have to do. That's probably a regulation, because they're using that to apply it to someone else, and they're going to rely on that because they're going to then go to that person and say, no, you didn't follow our rule. Well, it's a general applicability. It's a rule that you've put in place, and you're enforcing it against somebody else. If it's just an individual one-off determination about a licensing decision, probably not. But anytime it's a broad perspective that's generally applicable, you should be thinking about a regulation under 233B. General applicability examples. There's some case law here. I'm not going to go through it, but I did want to include a slide about it since the materials will be available. Just some good examples, some discussions. If you get into a position where somebody's saying something should be a rule of general applicability, some good references and quotes there. What happens if we're wrong? Sometimes people get tied around the axle of, well, what if I try to put something into regulation and I shouldn't, or I don't try to put something in regulation and I should? Short answer is, if you try to put it into a regulation and you don't have the authority for it, there's a good chance that the drafters at LCB will tell you you don't have the authority for it, and it'll be rejected. Good chance, because nobody's perfect, and sometimes things slip past the goalie. So if it did get all the way past LCB, might get rejected by the Legislative Commission, who has the authority to give thumbs up or thumbs down to regulations, to all permanent regulations at the end of the process. Even if it gets through them, might get challenged in court under 233-110, and they would find that it's not a valid regulation. On the flip side, if you don't put something into a regulation that should be, say you have a rule about how something gets interpreted, and you have it in a rule book, and you're trying to apply that to people, and you apply it to someone, and they say, well, this should be in a regulation. If they were to go to a court and challenge that, and it's found to have been a regulation that should have been adopted, they're not going to give that any deference, right? So you're not going to get the benefit of all the hard work you put into the policy to better guide the public if it should be in a regulation and it isn't. So definitely consult with your attorney and look at 233B, but that's some of the possible upside and downside. The good news is we don't have the kind of statutory fines that Ross talked about this morning in the ethical prohibitions. We don't have personal liability for regulations like Kevin scared you with this morning or this afternoon. So, but there are consequences for the agency if you do get it wrong. Part 2, creating regulations. I promised myself that I would pause when I got to different parts in case anybody had a question. I'm not going to assume that means I'm doing a good job. I'm going to assume that means that most of you are asleep or thinking about dinner. But that's okay. We'll go on to part 2, which is creating regulations, which is probably what you're here for anyway. So how do we make some? First, make sure you have the authority to do it, right? No general authority or no implied authority. You've got to be able to point to a statute that says, here, the legislature specifically wants me and my body with my expertise to create regulations regarding this issue. Second, before you start the process, understand that it's long and slow. There's 2 general aims that I think you see a lot. Is to maximize the opportunity for the public to comment. You'll notice as we get to it, we'll have workshops, we'll have public hearings, all of which the public can have input on. And then it will go to Legislative Commission again, where the public can show up. And it will ensure that the regulations do not conflict with the existing laws. There are 3 different types of regulations: permanent, temporary, and emergency, and we will go through each in turn. Starting with the least common, we're going to start with emergency regulations. very rarely used. Actually, none were adopted in 2025. Since COVID, there's only been 6 over the past 5 years. So I jokingly tell people to know these exist, but don't ever expect to actually use them, which is, sometimes they are needed, but it is rare. The process is the agency would submit a request to the governor, which he may endorse or reject, requires a specific statement of what the emergency is. These are very short time frame. They automatically die after 120 days. And they require some sort of emergency, life, health, safety. Obviously, this has happened since COVID, but there was a lot more emergency regulations taking place during COVID because there was an emergency. There are some public notice requirements in 233B, 613, 2, and 3. So if you find yourself in a position to create an emergency regulation, know that there are obligations to notify the public and go back and look them up. I'm not going to go through them here, but it's about, even in the times of the emergency, getting the public access to that regulation as soon as you can. So it's not the same as the permanent or the temporary process, but there is an obligation to try to notify them as soon as you are able to. The last one is just a practice tip, right? If you've got an emergency and you're putting this thing in place for 120 days, sometimes the emergency is going to be over in 120 days and you don't need it to last longer than that. But if you do, you should start the permanent or the temporary regulation process immediately, because the emergency regulation will automatically terminate in 120 days and it cannot be renewed. So you can't have back-to-back emergencies, right? That 120 days gives you enough time to go through the permanent or the temporary regulatory process. So if your emergency is going to last longer than 120 days, which you probably don't know at the first day of the emergency, go ahead and start that permanent or temporary regulatory process to get the successor regulation in place as soon as the emergency regulation lapses by operational law. Okay, temporary regulations. Temporary regulations are only available between August 1 of an even-numbered year and July 1 of the next odd-numbered year. Why, you might think? Well, temporary regulations are there because we have a legislative session coming up. And you'll see when we get to the permanent regulations that LCB has a role in preparing those regulations. Legislative Commission has a review ability of those permanent regulations. So as we are preparing for a session and going through a session, everybody at LCB and everybody in the legislature is focused on the law part of the laws, regulations, and other. So this temporary regulation gives agencies an opportunity to continue to adopt regulations while the legislature is otherwise occupied with the session, and it takes the legislature out of the loop. So we can still do, we being the executive branch, can still do our work without having to rely on LCB while they are gearing up for session. However, because LCB and the legislature are not involved, these are temporary. They automatically expire on November 1 of the next odd-numbered year. Identical permanent regulations may be adopted, but you have to go through that permanent regulation process, which is going to involve LCB drafting, as it's going to involve LegCom review. So if you do find yourself in a position where you're adopting temporary regulations, and these are very common, right, because the legislature is busy and there's a long period when they're available, be thinking about when you need to start that permanent regulatory process to ensure that there's no gap, because these, again, will expire by operation of law. And the process is virtually identical to the permanent regulation process, with the exception of the participation of LCB and the submission of LegCom. And I'll have a slide explaining that a little better later on. Temporary regulation checklist. This is a good tool. I'm trying to think if I should read this whole thing or not into the record. I don't think I'm going to read it. There's a workshop. There's a public hearing. There's a preparation of the language, which does not have to be done by LCB, can be drafted by yourself. It does not automatically go to the Legislative Commission. There is a gap between when it's adopted and when it gets submitted to the Secretary of State, and that is a 35-day gap that gives legislators an opportunity to pull it so that they can consider it if they want to. So they still have the ability to affirmatively take these regulations and review them, but they don't automatically go to the Legislative Commission. But that does create a little bit of a gap between when the regulation is adopted and when it becomes effective, because no regulation becomes effective until it's filed with the Secretary of State. And in the temp process, there's a 35-day window built in. And of course, they expire on November 1 of the odd year. Okay, permanent regulations. These are the exciting ones because these live forever, or at least until they're amended or repealed. Multi-step process here. The important part, and we talked about it under the temporary regulations, is you will need to get language from LCB. These are going to be permanent rules with the authority of law. So the lawyers who are the experts in drafting laws are going to be the ones to draft them. You will also have a workshop, which will require 15 days notice. You will have a public hearing, which will require 30 days notice. And then after your public adoption hearing, your regulations will go to the Legislative Commission. That is the commission of the legislature that reviews all regulations. They meet every 2 to 3 months. And again, permanent regulations will not be they won't go to Secretary of State until they've been ratified by the Legislative Committee. Permanent regulation checklist. This is very similar to the temporary regulation checklist. And I'm not going to spend a lot of time on it because I think the next slide is actually better because it's a comparison. So what you kind of see here is the differences between the temporary and the permanent. Both of them have a workshop to start off with. There's a requirement for a 15-day notice. There is a small business impact statement, which means the agency must review the impact that the regulation will have on small businesses and take certain measures to ascertain whether your regulation is going to impact those businesses. 15 days notice, that gets posted. Then there is the actual drafting of the regulation, right? So the workshop is kind of, it can be first, can be sort of a community gathering where everybody tells what should be in the regulation, what should not be in the regulation. So you don't have to have any language drafted at that point. It can be sort of a more informal discussion. You can also have language if you want. If you want to come to the workshop with a proposal, that's fine too. So the next step in this, in both the permanent and temporary side, is the creation of language. On the permanent side, that is the drafting from LCB. So you'll submit the request for the regulation to LCB. They'll give you an R number. They are supposed to give you language back within 30 days. In reality, that doesn't always happen because sometimes the request to LCB is not necessarily answerable, or they may have some questions. So it could take a little bit longer if there's some back and forth with the drafter about what is actually needed or what should go into the regulation. You'll eventually get language back from LCB on the permanent side. On the temporary side, you're on your own. Work with your attorneys, come up with language that you think is the best language available, and you do not have to go through the LCB process because those people are all working 90 hours a week generating laws for us. Next step is the adoption hearing. These are identical on both sides. There's 30 days notice here, so you have to post public notice for 30 days. You have to include the proposed language for adoption, so whether that is language from LCB with an R number attached to it, or whether that is the language that you have worked on with your attorney that says this is the language that we want to adopt. Whatever it is has to be posted well in advance to give the public an opportunity to review and come to your adoption hearing and tell you either how great your regulation is or whether it could be improved slightly with some modifications. After the regulation is adopted, the processes deviate again. If it is a permanent regulation, it then gets sent to the legislative committee, where it will be heard at the next committee meeting, as long as the next committee meeting is more than 10 days in advance of when you send it out. So you don't get to send it Thursday at 5 p.m. and say, oh, can you have it on the LegCom meeting for Friday morning? No, 10 days out. But as long as it's 10 days out, they'll put it on the next agenda. On the permanent side. On the temporary side, you don't need to send it. But you do need to hold it, and that adoption will start your 35-day clock, which gives the legislators a chance to say, oh, this entity adopted this regulation. We might want to take a look at it. We might want to pull it and put it on our legislative agenda for review. If they do not, the next step is filing with the Secretary of State. So on the temporary side, you send to the Secretary of State after the 35 days, and it gets adopted. On the permanent side, after the Legislative Commission has reviewed the regulation, they will, if it's approved, they will go ahead and submit it to the Secretary of State, at which time it will become effective. Submission to LCB, already went over this a little bit as we discussed. Permanent regulations go to LCB for official language. Language comes back within 30 days based on that statute. Can be extended if there is some confusion. And like I said, language not needed for the workshop, but it is needed for the adoption hearing. Workshops. This is often the first step in the process. Specific notice requirements are in 233B 0608. 15 days notice must be posted prior to the workshop. You do not need the language from LCB. There is some forms in our manual, which was included on the first slide in this presentation. You cannot have the workshop on the same day as the public hearing. That is an explicit statutory bar, which means I think you can infer that the legislature would like the information from the workshop to inform the regulation before it goes to the hearing. They did not prescribe a number of days between the two, but they cannot happen simultaneously. So I think that is a good indication that they would like those to not be stacked up on the same day. Small business impact statements must be posted as well. We talked a little bit about how you have to take some time and review the impact of your regulation may have on small businesses. Workshops must follow the open meeting law procedures. We had open meeting law training this morning. I talked a little bit in the very beginning about how regulatory authority can be given to boards and commissions, but also can be given to individuals. Attorney General has some regulatory authority. Secretary of State has some regulatory authority. They're individuals, so they're not normally subject to the open meeting law, but when they are adopting regulations, they are. This process will require them to have an open meeting. Only difference is instead of having a dais with 6 people, normally will be one person who is either the Attorney General, the Secretary of State, or one of their delegates who will be taking the action as allowed. You can have more than one workshop if you want to. If you have a lot of public participation, if you have a lot of public interest, it may behoove you to have more than one workshop. It may take a while to get the language worked out. The requirement is one, but you can have as many as you want. That doesn't mean that you're required to. Even if the public says, you know, we really think we need multiple workshops, you can say no. We only need one, and that's all that's required. So that's something that's in the agency or the board or commission's control of how many they want to have. No workshop required before the second or subsequent public hearing, 233B 0612. So think about if you go to an adoption hearing for whatever reason, your board says, no, this isn't ready yet, we want you to do some revisions. You don't have to go back to the workshop again. You can just go to another public hearing. Similarly, if you go all the way to the Legislative Commission and they give you a thumbs down on your regulation, they don't like it for whatever reason, you don't have to go all the way back to the workshop. You just think about chutes and ladders. It's not go back to zero. You just go back to the regulatory adoption phase. Public hearings, again, these ones you have to have text at. There are specific notice requirements, and the text of the proposed regulation is included in those. There's a 30-day posting requirement of the intended action. That's 233B060. And there's a required form for the notice of intended action. These also must follow open meeting law processes. So same rules, even if you're an individual, Secretary of State, Attorney General, have to follow open meeting law on these. And again, have to have the approved language from LCB, although some non-substantive modification is allowed at the hearing. One of the questions we get a lot is, well, what's non-substantive mean? How much changes can I make? That's really hard to answer in a vacuum. But think about how this is a public process and how it is designed to give the public an opportunity to show up and opine on the regulation. And if you are deviating from the late regulation and the proposed text in such a way so that the public might not have known where you ended up, and there was somebody who was sitting at home and read your notice and said, oh, that regulation's fine, but then you deviate into a place where they might have wanted to come and give comment, you've probably gone too far. So that's the lens that I encourage clients to look at is, would the public have known that this is one of the possible outcomes when they saw the language get posted? I don't want to tie people's hands because the boards need the ability to make the changes and put the regulations in the best place possible. But make sure that you're thinking about whether the public would have shown up had they known what kind of changes were going to be made. A couple public hearing tips. Read your language multiple times to make sure it says what you want to do. Because as we said, long process, workshops, regulations, you can always amend things, but then you got to do more workshops and more regulations. So try to get it right the first time. Ask a coworker from a different department to read it, because a lot of times you're familiar with the language in a way that somebody who doesn't read these things often is. The language is going to be public, so you can share it with whoever you want to. Have somebody who doesn't know anything about your department read it and say, does this make sense to you? Is there anything that you think we should change? How can we make this more clear? Agencies shall fully consider written and oral submissions with respect to the proposed regulations. If the public comes and starts talking to you about your regulation, feel free to engage with them and explain why the policy choices that you have made are the ones that you have made. Sometimes you will get to agreement and you guys will reach a consensus on what is the best policy. Sometimes you won't, but the record will be clear and it will be, people will better understand where you're coming from. It may lead to some changes and some improvements in the regulation, but the process of going through the back and forth with the public, I think, is helpful for the record, and will help prepare you for any questions you might get at the Legislative Commission as well. And I think it's also important, if there is a challenge, to have the record reflect that the submissions have been considered. It's not that, oh, we didn't want to hear from that person because they show up and they object to all our regulations and they're kind of just a pain. They've got an opinion and you should engage with their suggestions and their requests. Final Legislative Commission review. After the public hearing is submitted to the LCB, LegCom can reject or approve a regulation. If rejected, doesn't become a regulation, you can request a written response from LCB or from the LegCom, but you really don't need to. Usually the record is pretty clear what they have a problem with and what they want to see changed. So in practice, that's usually not done. Usually when you get to this table and the legislature say, well, I really don't like this aspect or I have concerns about this, it's pretty clear the changes they would like to see to have a successful regulation come back. So normally you can make those changes without requesting a written change. And again, when you go back to finish the process, you don't have to go all the way back to the workshop. You can make the changes and go to the adoption hearing to have a new regulation adopted. Once Legislative Commission approves, it is accepted and filed with Secretary of State, at which time it becomes effective. So it doesn't become effective during the process. It has to go all the way through, and then once it's across the finish line is when the effective date is. Legislative Commission preparation. If you do end up with a regulation that's gone all the way to the finish line and you're going to come to answer questions from the Legislative Commission, be prepared to explain the need of the regulation, why it's there. Prepared to explain concerns you've heard from the constituents, efforts that you went to address those concerns, why the version that you have is the best version. Also be prepared to explain the non-controversial parts of your regulation, because just because the public cared about one thing doesn't mean that the legislature is not going to have a question about something that you thought was non-controversial. So know it well, be prepared, and the more prepared you are, the less chance that anybody asks you about it. At least that's generally my experience. But yeah, questions are unexpected, and you should just be prepared to talk about every aspect of it. Part 3, Killebrew, a case study. I will pause again for regulations, questions, comments. Nicole.
Okay, so Ledge Commission rejects your reg. You can revise it and resubmit it within 60 days. But say you change that language, do you need to go back to another adoption hearing if you substantively change the language before resubmitting it to the Ledge Commission?
Yeah, so the question for everybody in Vegas was, you've adopted a regulation, it goes to the Legislative Commission, the Legislative Commission rejects it. Nicole wants to know, when you change the language, do you have to have it readopted by your public body or your agency before you go back to the Legislative Commission, right? So the answer is yes. You need to have whatever the final version that's going to go to Legislative Commission, you need to have it approved by the body. So you don't have to go all the way back to the workshop, but the only version that you have blessed by your public body is the version that was just shot down by the LegCom. So you need the public body to bless the version that you are going to move forward to the Legislative Commission. So yeah, you do need another public meeting with notice to the public, with revised language to the public body, and then once that gets approved, you can go back to the Legislative Commission. Cool. On to Killebrew. Perhaps the best part of this is it answers the question, how long does it take from somebody to have a good idea about a regulatory change and the legislature to say, we think you should change this regulation, to adopt it, have it challenged in court, go up to the Supreme Court and get a decision that renders it legal? And the answer is about 6 years. So if anybody wanted to know how many licks it takes to get to the center of a Tootsie Roll Tootsie Pop, 6 years. I appreciate the chuckles. It makes me feel like not as old as I think I am. So you can see here, 2017, the legislature looked at the buoy and the pier permits and the costs that Nevada was charging and decided that they were too low. They issued a directive to the registrar, again, putting that responsibility onto the agency with the expertise to go change these in regulation. The bill was pretty good because it said, we think these are too low, and it said explicitly, go change these things to make it more in line with fair market value. So the division undertook a rulemaking. Great job. And they did a lot of work. There's a summary here. Historical review of the statutory fees, a review of other states and similar buoy and pier permits, valuations of fees charged by marinas and other businesses, so looking at what was happening in the commercial space, in-house evaluations of fair market value, independent appraisals, and because most of the buoys and the piers in Nevada are on Lake Tahoe, They also looked at what California was doing and what the buoys and the piers were there. So they did a lot of work. They also solicited public comment. They had the benefit of seeing the legislative hearings, so they knew that this was going to be subject to something with a lot of strong opinions. And I think that the actions they took reflect that. Individual notice to all existing permittees, posted in every Nevada library, advertised in newspapers, 5 public workshops. Remember, we only have to do 1. They did 5 because this is an area of a lot of interest to a lot of people, and they wanted to do a lot of due diligence. And in response to those comments, remember we talked before about engage with the comments. Don't just think that you've got it right the first time. If the public shows up and say, hey, you're going to take these fees from $30 to $200, maybe phase that in. Don't hit us with $200 the next year. Maybe go to 50 and then 100 and ratchet it up slowly. And they listened, right? So in response to those comments, they phased in the increases and they decreased them a little bit. So you can see the result at the bottom. Uniform annual fees went to $750 annually for piers and $250 for buoys. Previously, $50 for piers, $30 for buoys. Significant increase. I'm sure everything's going to be fine, right? Nobody's going to have any problems. Unfortunately, no. Appellants, property owners in Lake Tahoe, one of the most beautiful places on the planet. How fortunate you must be to own property in Lake Tahoe. You should be thankful every day that you have this opportunity and that you have the opportunity to own a buoy or a pier in one of the most beautiful historic places in the world. You wouldn't want to waste your time on regulation, would you? Or litigation over a regulation. So they petitioned the court for a 233B 110 challenge, which is a request for a declaratory judgment that the fee-setting regulation was invalid. So that's the first step. We go to district court. They say that our fee structure was invalid. District court granted summary judgment finding the regulation did not violate statutory or constitutional provisions and did not exceed the statutory authority. Remember, we talked originally about going back to point to the authority that you have. The legislature specifically told me to set authority on buoys and piers. That's exactly what we were doing. You wouldn't want to take that to the Supreme Court. More wasted time and attorney's fees. But yes, they appealed, arguing that the district court could have reviewed whether the regulation was arbitrary and capricious. So the argument is not necessarily just that the regulation exceeded our authority, but that it was arbitrary, right? And they're asking the court essentially to evaluate the regulation and whether it was well thought out. Arbitrary and capricious, I think you heard under Todd's section, which is an argument that a public body really just kind of got it wrong, did something that reasonable people wouldn't do. They just kind of acted without logic and without sort of well-measured judgment that you would expect from a public body. So one of the issues on appeal is what is the standard of review for challenges to the validity of an agency's regulation? Is it the arbitrary and capricious standard, or is it really just whether it was within the agency's authority? A lot of text here. Bottom line is the court said that the arbitrary and capricious standard is not applicable to regulations. It is applicable to individualized determinations in the individual context, license revocation, things like that. But in the administrative rulemaking context, what they're really looking at is whether the agency was within the statutory authority that it was given. So again, the link to this whole case, in case you want to read it, and I recommend that you do. It's wonderful. But the bottom line here is the last line. There is no room for us to read the arbitrary and capricious review into the standard provided by the statute. The court eventually determined that state lands did what they should have done. They looked at the appropriate things that the court wanted them to look at. They evaluated how to increase the fees in conjunction with fair market value, and they set a fee schedule that was completely consistent with the direction that the legislature had given to them. And they took the opportunity to clarify the standard, that it isn't an arbitrary and capricious standard. It is just looking at whether the agency is acting within the authority given to it by the court. So it's a great decision that took a lot of work by the agency and by the lawyers involved, and they did really good work. So thanks to all of them. Pause here before final thoughts, knowing that I don't have much time left. Any questions? What? The question was, how many buoys and piers could you have bought with the attorney's fees that were spended by the litigants in Killebrew? The answer is I don't know, but you're right, probably a lot. But yeah, I mean, I think that one of the, other than this being a really good example, I think it's a good example of a division doing what the legislature told it to do, whether it's going to be controversial or not, doing the right thing, listening to the public, going through 5 workshops when only 1 is required, and still getting sued, right? Sometimes you do the right thing and people not going to be happy with you anyway. And in that case, that's why the attorneys are around, because we make the legal arguments, we go to the courts, and I think the court got it right and fully vindicated everything that both our office and the division did. So I think it's a great story for anybody who's a public servant who feels, hey, I'm getting attacked by this, what should I do? I think the answer is you do the right thing, you follow the law, and the attorneys will defend you and let the chips fall where they may, and if the court gets it right, you get a great decision, and you get to talk about it in a training, years and years and years. So anyhow, I love the case. It's outstanding. Final thoughts, just a couple of random things before we go. What if a member of the public thinks an agency should adopt or appeal a regulation? Can they prompt an agency to start the rulemaking process? Of course they can. The answer is on the slide. NRS 233B-100 allows you to petition a rulemaking agency and say, hey, I've got a great idea for a regulation. Here it is. Why don't you go ahead and do this? Sometimes that could be a repeal of a regulation. This one's old and outdated. Get rid of it. It could be an amendment. You need to narrow it or expand it. Could be a whole new one. Whatever it is, they can submit that petition. There's a requirement for the agency to respond. They don't have to start the process, but they do have to respond to the petition. And if you get one of these, I would say it's a precursor to litigation, because somebody doesn't like what you're doing, and they're likely to challenge you some way or another. So that response that you're going to give, that 30-day response, is probably your first document that's going to be in court, that's going to be stating your position of why the regulation should not be adopted. And if it should, just go ahead and start the regulatory process, because that's fine too. Next question. Does the agency have a certain amount of time to complete the rulemaking process? We get these questions every so often, and the answer is yes. You've got 2 years to complete it. The sanction, if you take longer than 2 years, isn't really severe. It just means that the head of the agency has to show up before the Legislative Commission and explain why it's taken 2 years to complete the regulatory process, which, I mean, it's more public shaming than anything else, right? The director or the chair has to show up and say, oh, I'm sorry, this happened and that happened. And then it's sort of a public embarrassment thing so that they can just get the process moving. But 2 years is that window. So once you start the process, pursue it with diligence to try to get to the end. I don't think I've ever had a client have to do this. But I certainly have been asked the question. And I think when the answer is, well, yeah, you got 2 years, otherwise the director needs to show up, it's like, oh, okay, we'll go ahead and finish that in 2 years. But just know that that's out there. And lastly, great power comes great responsibility. Only Spider-Man reference of the day. Is an agency required to review its regulations periodically? The answer is yes. Under 233.050, agency must review its regulations at least once every 10 years. But you review them more often. You know what's going on in your regulations more than everybody else does. I advise anybody with regulatory authority to just keep a list of things that are in need of updating, in need of review. As things come up, oh, this wording isn't quite what we wanted, put it on the list and work your way through whenever you're going to have a regulatory process or regulatory adoption to try to make sure that those regulations are as modern as you can get. Kevin talked about some of the problems of when we have an NRS that wasn't updated since 1930. If you go through your regulations and find that they haven't been updated since the 80s or the 90s, there's a good chance that there's stuff in there that could be cleaned up, disposed of. So statutorily, you got to do it every 10 years anyway. If you make it periodic, then there's less to do at the end of every 10 years. And you can feel like Spider-Man because you have this power to create the regulations, and the responsibility is to make sure the bad ones go away. That's it. Here is the CLE credit link. I will leave it on the screen as long as I am humanly able to so that everybody can get their CLE credit. But as I'm leaving it on, I see people rapidly taking pictures. I'll answer any other questions that anybody might have. Yes?
When you were talking about the members of the public being able to petition the board to start the rulemaking process, is that literally a piece, like, is there a form that they fill out, or could that even be just an email or a public comment where they start that petition?
Good question. So the question up here in Carson was the petition to start the rulemaking process. Is there a prescribed form that they have to fill out, or can they just, kind of give public comment and a hearing and say, I think you guys need a regulation that makes, all animals have to be tested for rabies, which is a bad example because you have to kill something to test for rabies. But whatever. The answer is no. There's no form. NRS 233B or NAC only 233B. I think only has one section, and I think it's the form for the adoption, the notice to adopt the hearing. So there is no form to petition. I have had people send them in letters. I've had people send emails. My general advice is if it says 233B 100 on it, treat it as if they have effectively invoked that section and respond within 30 days. If they haven't specifically invoked 233B 100, just treat it as the public coming to you with an inquiry that you should respond to, as any other member of the public is deserving of, thought and respect. But I wouldn't invoke the formality of that petition because you've basically opened yourself up to more responsibilities than you needed to. So does that answer the question? Other questions? Cool. Well, that I think concludes everything. Rosalie, I don't know if you wanted to wrap up while I'll stall to see if you're running to the dais. I will say that having sat here through almost all the presentations today, it's continually impressive to me how much knowledge and expertise we have in the state. A lot of it came from the Attorney General's office today, but also legislative auditors and Ross from the Ethics Commission. These trainings are great, but I have the good fortune to interact with most of these people on a daily or weekly basis, asking Kevin contracting questions, asking Rosalie open meeting law questions. And they really are working every day to make sure that we're following the law and the processes, and where those processes and those laws are kind of not functioning at their best, they're trying to figure out ways to improve them. So I'm fortunate to work with all of them. And just a final thank you to all of you, for everybody who's involved in public service, whether you're on a board or a commission, you represent one. Thanks for the work that you do for keeping the state running on time. Rosalie has not run to the dais, so I think that means we're done. So everybody drive home safely. Have a great rest of your day. Thank you.
Yeah, I was one of